Hi, good afternoon. Today we're going to be talking about what happens if you have restrictions due to your work injury. Maybe they're permanent and you aren't able to get a job. Your employer is saying they can't accommodate you. You've heard something called the Americans with Disabilities Act. You're not quite sure what that means, how that can help you. Today we're going to talk about the interplay between the Americans with Disabilities Act and workers' compensation. Hi, my name is Kaplan Morrell, and I am an attorney representing injured workers in Colorado since 1995. And I've been working with people who have been injured with restrictions and how they interact with ADA. And again, if you like or find this video helpful, please like, subscribe. And with that, let's dive into it. Okay, so we're going to talk a little bit about what workers' compensation, what rights you have when you've been injured on the job. You've got restrictions. Is there an obligation for the employer to accommodate you? And we're going to talk about what the ADA is, and we're going to talk about how they come together in a case. So, workers' compensation is a state law which says that if you are injured on the job, regardless of who's at fault, you are entitled to basic benefits. And those benefits are you're entitled to medical care, lost wages, some compensation for what's called permanent impairment, and in extreme cases, permanent total disability. There's some others, but I'm somewhat simplifying. One of the most common questions is, hey, isn't there a law where my employer has to accommodate me? Isn't there some sort of protection in the Workers' Compensation Act where it says they have to give me a job? And the answer is no. Workers' compensation doesn't have any obligation on the employer. There's nothing a judge in Colorado can do in workers' compensation to say, hey, employer, you need to give giving your injured worker a job. Okay, sometimes employers will do that, particularly as a temporary accommodation, but they're not required to by law. So that's where the Americans with Disabilities Act may come in. Now, not all employees are covered by the Americans with Disabilities Act. Not all employers are covered by the Americans with Disabilities Act. Sometimes it depends on whether or not you are considered disabled as that federal law is interpreted. It's very broad. You really do need to have specific legal advice on whether or not you have any protections. But essentially what the federal ADA law does is it says if you are considered disabled, if you meet the definition of disability for the Americans with Disabilities Act, your employer can't terminate you simply because you have a disability, so long as you are capable of doing the essential functions of that job with or without reasonable accommodations. And that is a key thing. The ADA doesn't force your employer to invent a job, to dramatically restructure a job. It only requires employers to offer what's called reasonable accommodations. What does that mean? Let's suppose, and this is the example I kind of always give, let's suppose you have restrictions which basically say you can't lift over your shoulders. And part of your job is you work at a library, and part of your job is to take the books and put them up on the shelves, and some of those shelves are above your shoulders. And because of your restrictions, you can't do 100% of that work. What is a reasonable accommodation? What it won't be is you're not going to be able to force an employer to say, don't give me that part of the job, make someone else do it. You're not going to be able to force the employer to say, hey, from now on, I don't want any books stored on shelves that are higher than my shoulder. That's not going to happen. You're not going to be able to tell get the employer to lower all the shelves. However, what you could do is you could say, okay, if I was given a $60 step stool, and so by stepping up on the step stool, now I can put the books on the higher shelves without raising my arms above my shoulder. I can do that. That is going to be a reasonable accommodation. Okay? So you're able to do the essential functions of the job. The accommodation is very minimal, very light. It allows you to do the job as the employer needs it to be done. That's going to be considered a reasonable accommodation. So how do these two kind of interplay? In workers' compensation, during your medical care, you may or may not be offered what's called modified duty. Sometimes employers will offer modified duty for a variety of reasons. Often it is to reduce the cost of the claim. They're not having to pay out as much if you aren't off work. A A lot of times folks who are working meaningful modified duty get better a lot quicker, and it works for both sides. Once you're placed at max medical improvement, the doctor gives you permanent restrictions. Hey, am I going to be allowed to continue to do this modified duty? And if the job is a real job, in other words, would they normally pay someone to do that work and just that work, then maybe you can stay there. Or if you can go back to your old position, you can still do the essential functions of it, and there's some reasonable accommodation. You should have that discussion with your employer. Say, hey, here are my permanent restrictions. I still think I can do this job, and here's the little changes that I may need to have. And as long as you're able to do the essential functions of the job, the employer should, by law, accommodate you. Again, it's got to be reasonable accommodations, and it can't put too much of a stress on employers. So for example, if you said, well, I can still do the job, but now it's going to take me 3 hours to do this task rather than the typical half hour, you can imagine that's probably not going to be considered a reasonable accommodation. But the key point in here is 3. Number 1 is you've got to be very familiar with what your permanent restrictions are. You've got to start that conversation with the employer, and it's an interactive process. They don't get to just say, oh, well, you tell us. It's an interactive process. And number 3, you've got to come at it with a heart of, hey, I can work here, I can do the job as well as I used to, and let me show you how. You don't get to come into the conversation saying, well, here you've got to accommodate me and better be something I like to do. You've got to come into it with a heart of somebody who's like, I can work and I can do this. Now, if you can't go back to your regular job, but there's another job that's open and that you're qualified to do, you can apply for it, and same thing. Typically, the employer must try to offer that as a reasonable accommodation. But as always, it's a little complicated. It's always very fact detailed. A situation that works for one person may not work for the other, and that's why it's so important for you to get good legal advice when you are dealing with this issue. And that's why if you text us 970-356-9898, let me know that you got this video and you want our free tip sheet, which is how to hire an attorney. That's texting 970-356-9898. Say, saw you on YouTube, give me the tip sheet on how to hire an attorney. I will happily give you the tip sheet for free, confidential, no obligation, etc. I may ask you for a review or a like or a subscribe. That would be very nice. But we'd be happy to help you be able to pick an attorney, not just a workers' compensation attorney, but an attorney for any of your needs. And this tip sheet gives you the 3 questions I would ask any attorney I was thinking about hiring. Okay? And with that, if you or anyone you know is injured on the job in Colorado, let them know that there is a law firm that does workers' compensation. This is what we do. We've been doing it since 1995. We would love to be able to help you, your friends, neighbors. Please give us a call, 970-356-9898. Text us at 970-356-9898. We offer free consultations. We offer contingent fee, which means that if we don't get you anything, you don't pay us anything. And with that, thank you so much for spending part of your day with me today. Bye.